that because they don't want to lose this, right?
Yeah.
Look, these lawyers are making billions and billions of dollars, though at our expense, okay? Now, do you know this? Back in 1958, now the Select Committee in Washington, researched this, and this is going to shock you all, is that the American bar was placed on the communist activity list.
It's in the congressional record.
People, listen to Jim.
It's in the congressional record that Congress has declared the Attorneys League and the Bar Association to be anti-American and communist. It's in the congressional record. They can't make that go away. And it is. It's a conspiracy against us. I mean, Congress has admitted it on the record. People need to wake up and understand what they're doing.
So, Kevin, let's get back now. That the judge leaves the room. She comes back in. Now, before she left, she had no idea of this new rule, right? No clue. So she comes back in, Jim, 5 minutes later.
What was the rule?
And says that we've discovered a new rule. What was the new rule?
She said a recent rule, which was Rule 207.
207. What's the heading of the rule? Rule 207.
Representation in magisterial district court proceedings.
And do you know that that rule is not new at all? That rule has been on the books for years, but nobody has read it, okay? Why? Because it did not support the banking views. It did not support the American bar, okay? This rule here supports us. So it just proves now that if you understand and study the rules and use their own rules against them, that we will win, okay? So what does that rule say, Kevin?
So she says, well, come up to the bench and read it. But make sure you only read A and 1.
Only read.
Only read A and 1.
Right, because they don't want you to read 2 and C and all the other ones. But go ahead.
So I read out loud to the court and to the people that were sitting there, individuals may be represented by themselves, by an attorney at law, or by a representative with personal knowledge of the subject matter of the litigation and written authorization from the individual to appear as the individual's representative.
Okay, now let's discuss this, guys.
Yeah.
Number one, it says here is that it has to be a written what, Kevin? Authorization.
Correct.
From who?
From the plaintiff
And who is the plaintiff in this case?
at asset acceptance.
Okay, but do they have an assignment?
No, they did not.
Did they come into court with some type of a 207 form that allowed this lawyer to represent them?
Not at all.
Not at all. Jim, what were you going to say?
The one she had you read, it's not even for corporations. And did you agree with her on this rule, or did you object to the rule?
I said, I object. I went back to my desk, got the civil complaint that was from her office, and I said, well, here it says that Chase Bank assigns asset acceptance the assignee. I said, is there another document that officially states that other than a document from your office? Did Chase give that permission to asset acceptance to be the assignee? She said there's none needed.
There's none needed.
This is what they do in courts to
None
us.
needed.
They lie to us, and if we don't know better, we agree to it, we acquiesce to it, and then they get their judgment, and they do whatever they want.
The real crime is this. You raised 7 kids, okay? You work now for 30 years of your life supporting their government, and when you went into court, and with this judge, now this judge has just denied you your basic rights to the Constitution of the United States. And to her, she don't really care. All she's there for, Kevin, is to ramrod you to get a judgment so they can deposit it into the court's bank account. That's all they care about. Okay, Kevin? Look, it has nothing to do with your rights anymore. It has nothing to do with that. It's only about protecting the bankruptcy of the corporate United States, and there's only one way that they're going to get it. They're going to have to start stealing it from people like me, you, and Jim, okay? But that you're just on board. Now, whereas Jim and I, we've been around this game for a couple years, and we don't want to participate in their games anymore, okay? And we'll not. We're going to expose all these corrupt people that by doing shows like this, and believe me, it's going to be all over the United States. This Judge Heck, if she runs, if she survives this attack, she will not get a fraction of the votes that she did get to obtain that seat. And before I'm done with you, I'm going to see to it that you're thrown off the bench, okay? You cannot treat people like you. How many people now has she done this to besides you? Probably hundreds, okay? Jim?
As long as we're talking about the rules, and under 207, because it's a corporation, it has to be assigned. You know, they have to have personal knowledge of the subject matter, litigation, and written authorization from an officer of the corporation.
Was there that?
So it would have to be an officer of the corporation that actually gave that attorney permission, and then be an officer of the corporation from Chase Manhattan Bank.
Here in our state, they have a professional rules of conduct. And if you go back, Kevin, are you familiar with 3.7?
3.7.
Yeah, that's what I brought up to her next. I said,
Now, wait a minute now. You actually raised to the court their code 3.7.
yes.
And what does 3.7 say, Kevin?
I said, I object, Your Honor, under the rules of professional conduct, Rule 3.7, a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. The plaintiff lacks standing, therefore this court has no personam jurisdiction because there is nobody to cross-examine. And then the judge said to me, Rule 207A1 is the rule that I will go by, and I will allow this lawyer to be the plaintiff.
The lawyer cannot even open up his mouth.
Yeah.
It's like this. What firsthand knowledge does this lawyer have?
Absolutely none, because I think he got the case mailed or faxed to him within an hour or two.
Right. Before trial, right?
Correct.
Right. So, Jim, here we go again. Okay. He goes into court thinking it's going to be an honest court, and now the judge doesn't know anything, so she's got to get off the phone, right, make a call. And more than likely that she called the debt collector asking them, now what am I supposed to do?
Yeah.
Oh, what you got to do now is use Rule 207. But 207 doesn't even apply to them, okay?
Yeah.
But Rule 2002 makes it very clear that the plaintiff has to be the one that originated the complaint. Chase didn't originate this complaint, did they?
No.
The assets did.
Yes.
There's no assignment there, and there is no one from Chase Bank that even allowed him to represent him. They have no standing, just what you raised.
Right.
Now, with what you just read there, Kevin, or stated in court now, that was great. And what did the judge do? Jim?
Ignored it.
Ignored it. Says, we're not going to follow those rules. But 5 minutes before now, when you asked the courts, is this court governed by the rules of civil procedure? What did the judge say?
She said yes.
She said yes. So obviously, Judge Heck, you're a liar.
You've lied for the record.
Okay? You're a liar. Okay? Plus, you violated this man's personal rights. Okay? And for that, you're going to be exposed, and the American bar is going to get taught a lesson that the American people are sick and tired of your stuff. Okay? We're not going to take it anymore. It's that simple. Okay?
Yeah.
Okay. What else occurred?
Well,